Hi, this is attorney Vishal Chander. I lead the immigration practice at Gardere Sewell LLP. And today we're going to be talking about immigration policy changes and the tech economy. Today we're going to be focusing on a couple of different things, but really we're going to be focusing on recent changes and news to keep in mind, which are going to affect companies and employers which rely on technology workers or companies that are in the technology field. Here we're going to generally start with an overall look at what the current situation is for business immigration and immigration generally in the United States. We're going to talk about the recent H1B filing season, which happened in April. We're going to talk about our President Donald Trump's Buy American, Hire American executive order, and some of the other actual memos and policy statements that have been issued by USCIS in the last year, which are going to have an impact on H1B related occupations. So first, we're going to talk a little bit about the recent immigration actions that have occurred with relation to immigration. And I think generally, not even for specifically business-related immigration, we're seeing a trend towards greater enforcement and scrutiny of immigration applications. So, for instance, for the first time, USCIS has recommended ending of the temporary protected status program for Haiti. And this news has triggered concerns not just amongst Haitians, but other countries that are currently receiving temporary protected status. Individuals from those countries are looking to move to other types of status, so that since they're concerned they can't rely on TPS in order to remain in the United States longer. In terms of greater scrutiny and enforcement, we have expansion of the government's inquiry into social media handles for the ESTA program. The ESTA program is the online screening form which must be completed prior to travel for individuals who are going to be traveling under the visa waiver program. And the EVIS program is a similar online pre-screening system which is used currently by Chinese nationals to update their informational status prior to traveling on a B1 or B2 visa to the United States. So for the ESTA program and the EVIS program, there is now a request for provision of social media handles. And we can expect that the EVIS program will in the future be rolled out for other countries, not just China. We also have the rollout of the Victims of Immigration Crime and Engagement program, something which you may have read about in social media, that the program was inundated with prank calls regarding aliens from outer space on the initiation of the program. But this program is designed to provide victims of crime committed by aliens in the United States to receive updates on the immigration proceedings initiated against those individuals. The other two things that give us a general idea of what the current situation for immigration policy is the executive order creating a sanctuary city ban and also the controversial so-called Muslim ban, which both of those issues are being litigated in the federal courts and have currently been enjoined from enactment. So in that context, we can look at the H1B season. So as we probably know, and as most of the attendees of this conference know, The H1B visa is utilized for sponsoring foreign nationals who are working in specialty occupations, that is, occupations requiring a 4-year degree in a field related to the occupation. And it's the principal visa that's used for companies which are employing high-skilled workers like computer programmers, engineers, and so on. And so there are a limited number of H1B visas issued every year and these are considered cap subject visas. So under the statute, we have 65,000 cap subject H1B visas. That number can be slightly less because some of those numbers are allocated to other types of H1B subcategories. And then we have an additional 20,000 visas available for individuals who are graduates of U.S. institutions of U.S. master's institutions. So individuals who've graduated from master's degrees or higher from U.S. institutions of higher learning. Because of the limited number of H-1B visas, the process is governed utilizing what's called the H-1B lottery. So filings for new H-1B visas are required on the first day of April. This year it was April 3rd, which was the first working day of April. And under the policy for the last few years, they are received for the first 5 business days. So this year, between April 3rd and April 7th, USCIS accepted cap subject H-1B petitions. And from those that are received, petitions are randomly selected for processing. So one of the myths or one of the misunderstandings in the media today is that H-1B visas are simply selected randomly only. And in fact, they're only randomly selected for processing. And the implementation of the system happened really when we first came out of the Great Recession, and in the first year where there was an H-1B filing season where there was an expectation that the H-1B filings would exceed the cap on the first day of filing. That same week, there was also extremely bad weather, and many shipments were delayed from getting to the processing centers on April 1st. So as a result, I think that USCIS created that 5-day rule back when, only a few years ago, when this became an issue. So this year we had a filing period between April 3rd and April 7th. And on April 17th, USCIS announced that it had received 199,000 H-1B petitions. On May 3rd, USCIS announced that data entry on all cap subject H-1B petitions was complete. That means that, on April 17th, they determined that they received around 199,000 cap subject H-1B petitions between April 3rd and 7th. And those petitions were then randomly selected for processing. Those that were randomly selected were issued receipt notices. And those that were not randomly selected were put into a pile for rejection notices to be sent out. So here, if you're an employer that has sponsored cap subject H-1B workers this year, you should have received your receipt notices by now. And if you have not received those receipt notices, you should expect them sometime this week at latest. Otherwise, if you have not received receipt notices for those H-1B petitions, it's likely that the H-1B petition was not selected for processing, and a rejection notice will be sent out. Now, the rejection notice is actually an important document for a reason that we'll discuss briefly related to OPT optional practical training. So here I just wanted to provide, the listing of H1B filing history. And here we can see, April 2013 was that first year when H1B petitions exceeded the cap on the first day of filing. And that was the year that the 5-day rule was implemented, so that those H1B petitions that were affected by the storm on April 3rd of that year could be received properly. Now, you can see that each year the number of H1B petitions has increased. And this year, the number of petitions went down by about 37,000 visas, 36 or 37,000 applications. So there's a lot of discussion about why there were fewer H1B petitions. I think that from my perspective, one issue is that there was some uncertainty on the part of many filers. Many employers made a last-minute decision as to whether or not to file H1B petitions, knowing that the uncertainty that was created in the media regarding H1B visas drew concern, and also because there was some concern about whether or not the application would even be selected. Many people were expecting much higher numbers of H1B petitions to be issued this year. A second issue is that many of the major companies, many of the companies which are the major consumers of H1B petitions, and that is many of the outsourcing companies which are based out of India, chose different strategies in terms of their filing process. So they filed fewer petitions. Many of them ceased practices which included things like filing multiple applications for multiple worker applications for the same position in an effort to make sure that at least one of the petitions, one of the potential workers would be selected. So that reduced the number. But I think another thing just to keep in mind, and this is just my opinion, is that the demand for H1B visas is a reflection of the economy overall. And so here, while uncertainty might be a factor in the reason why H1B numbers were down this year, there's also the possibility that this is a leading indicator that the economy is going to be slowing down and demand is decreasing. So those are just my thoughts, and I think it's just interesting to see this movement and demand for H1B visas. So I wanted to, before we move on, I wanted to reiterate why the rejection notice is important. And this is for those of you who have employees who are currently working under optional practical training, which is a 1-year period of practical training available to F1 students, that is, those individuals who are attending university in the United States, who have received their degree. Those individuals get a 1-year period of practical training during which they can work in occupations related to their field of study. And for those individuals, what's important to know is that so there's a situation that can arise for these individuals called the gap, meaning those individuals on OPT, their period of practical training may end prior to the H1B start date, which is October 1st. So the gap cap extension to the OPT was created under the regulations and basically covers that period of time where the H-1B or where the OPT worker would otherwise be out of status. And so this really, the situation scenario would be one where, for instance, OPT expires in May or June, and then that worker doesn't have immigration status until H-1B kicks in October. And so this cap gap relief remedies that situation. So here are the important things to keep in mind. So the automatic gap cap extension is triggered by the filing of an H-1B petition. It's not simply triggered by the issuance of a receipt notice. So when there is a filing, when there is an H-1B filing, that results in the automatic extension of OPT time. Now, the other important thing to keep in mind is that the automatic extension continues until the actual rejection notice is received. And so this can make a big difference for those individuals who aren't being selected for H-1B petitions. Those individuals may have a longer period of time to stay in the United States, or a longer period of time to determine alternatives to remedy their status so they can remain longer in the United States. The other thing to keep in mind is that when that rejection notice is issued or received, that's when the 60-day departure period begins. So for F1 students, there's a 60-day period that it's often referred to as the grace period, during which F1 students can depart, are given additional time to prepare to depart from the country. And during this time, they can also seek other status. They're still considered eligible for changes of status. So this gap cap relief and the use of that rejection notice is important for those employees who are not going to be selected for H-1B processing this year and may need to have additional time to either get extensions of OPT or pursue some other type of non-immigrant visa to continue work in the United States. So let's talk about the trends and potential changes that we see with under the Trump administration and generally trends that are ones that preceded the Trump administration. So on April 18th, 2017, I'm sure many of you saw the news where President Trump visited Snap-on Tools in Kenosha, Wisconsin, and gave a speech regarding Buy American, Hire American. And at that time, he signed an executive order which addressed issues like ensuring that in government contracting, there was a greater effort to purchase U.S.-made goods and services. And in that executive order, there was also some language addressing immigration generally. As we see here in Section 5A, that the executive order directed DHS to propose new rules and issue new guidance to protect the interests of U.S. workers in the administration of our immigration system. That Section 5B referred specifically to the H-1B visa program. And so here, there were suggestions that, the executive order suggested that reforms be made to ensure that H-1B visas are awarded to the most skilled or the highest paid petition beneficiaries. So what's the real impact of this executive order on current H-1B filings and on immigration policy generally? I would argue, and I think some others have argued, that this executive order really doesn't have any significant impact on immigration policy. DHS and the government are constantly reviewing and attempting to enhance both visa processing, benefit processing, and security and fraud abuse on a regular basis. And so this guidance doesn't change that goal and that existing policy perspective that DHS has. On the other hand, you know, the guidance to select the most skilled or highest paid H1B petitions may change how H1B cap subject H1B petitions are selected in the future. You know, for instance, next year we may have a lottery which examines what the salaries are of employees prior to rejection. But on the whole, this language doesn't really give us any new information because, you know, certainly the position to utilize the most skilled or highest paid petition beneficiary was something that was discussed by the administration well before H1B cap season. And I think that overall there's been a trend towards trying to ensure or trying to reduce abuses within the H1B system by DHS overall. But there are executive orders which should have us a little bit more worried. And so I'm referring specifically to unpublished and proposed executive orders that were placed on the desk of Mr. Donald Trump on his first day in office. And one of those executive orders was the Protecting American Jobs and Workers by Strengthening the Integrity of Foreign Worker Visa Programs executive order. Now, the language in this executive order didn't concern me that much, but in the rumor mill, there was a lot of concern. I mean, some interpretations finding that the order would rescind the H4 EAD program, that it would rescind the 24-month OPT STEM extension that was created by the Obama administration in the beginning of 2016. But the order does address some things in particular, mainly incentivizing expansion of the E-Verify program, performing site visits on third-party sites that are employing L1 workers, and scrutiny of the H1B and H2A programs, among other programs. So, you know, this executive order might be one to look to see what the real policy insights of the administration might be with regard to immigration and with regard to employment-based immigration specifically. Now, this order was never signed. It was never released publicly as one that would be potentially signed, but it is one that circulated and is considered to be one of the executive orders placed on the desk of Mr. Trump for signature on his first day in office. So, well, let's talk about the changes that have actually occurred and which will affect H1B adjudication for this cap subject filing period, and will affect H1B enforcement generally. So on March 31st, just the day before the H1B filing season would begin, USCIS issued a memorandum which rescinded a previous memorandum issued back in 2000 by the Nebraska Service Center, which held that computer programmer occupations were, generally speaking, specialty occupations. This finding on the part of the Nebraska Service Center back in 2000 meant that there was not a burden by an H-1B petitioner to affirmatively establish that the computer programmer position that was being offered was one that required a 4-year degree in a field related to that occupation. It would be accepted and assumed by the adjudicators that the computer programmer position was one that met the specialty occupation requirements. So in the in this order, this March 31st order, which rescinded that 2000 in this March 31st memo, which rescinded that December 2000 memo, USCIS takes a different position. One, it notes that the Nebraska Service Center is again adjudicating H1B petitions, and so recently, if you filed any extension of status applications, you would have noticed that those were going to the Nebraska Service Center instead of the California or Vermont Service Center, as previously was the case for many years. And so USCIS issued this memo mentioning that it wanted to provide clarity for individuals at the Nebraska Service Center given the prior service memo, the 2000 service memo. And in this memo, which rescinded that 2000 service memo, it discusses the Occupational Outlook Handbook, which is the guide which kind of we utilize, issued by the Department of Labor, which provides the descriptions generally for occupational classifications. And within the Occupational Outlook Handbook, it does state that associate's degrees are sufficient for certain types of entry-level computer programming positions. So USCIS is now taking the position that petitioners are going to have to provide additional evidence to demonstrate that the computer programming or even other types of computer-related occupations require more than just an associate's degree. And so, this memo is really going to affect. So there's a couple of things we need to keep in mind. First, this memo will affect our fiscal year 2018 filing. So all of your CAP subject petitions that have been filed are going to be subject to this memo. The second thing is this is really going to affect any type of computer programmer filing or other types of potential computer-related filings as well that are entry level or that are level 1 wage computer programmer or computer occupation positions. So that is, if your employee is receiving the low, if the employee's wage is related to the lowest wage level that's set out by the Department of Labor. The Department of Labor sets out 4 wage levels for occupations and then determines what the prevailing wage might be for any particular occupation based on the educational requirements, experience requirements, and special skill requirements, as well as supervision that's required in the position, and determines what would be the appropriate wage for that type of position in a prevailing wage determination. So for those H1B filings, again, where the level 1 wage is utilized, that means that there's 0 years of experience or 0 to 2 years of experience and no requirements beyond a bachelor's degree, no supervision of other workers, then those positions are going to be scrutinized for whether they actually require a 4-year degree. So employers probably should begin preparing documentary evidence to help support and respond to requests for evidence that are going to be issued for these level 1 computer programmer and entry-level computer programmer positions. And so specifically, you're going to look to the technical requirements for the position. That would be beyond what would ordinarily be expected of a computer programmer with an associate's degree. Now, here's the catch-22, and here's really what's important. This is really going to affect anyone who's attempting to file an entry-level or level 1 computer programming position. Because if the position requires anything beyond the minimal requirements, it's going to require a wage level higher than level 1. And so for those employers who are attempting to hire H1B workers at level 1 wages or wages that are entry level, for positions that really require workers with the knowledge of a master's degree holder or workers with the knowledge of multiple years of experience, they're going to be trapped in a potential catch-22, where by attempting to demonstrate that that the position that's being offered is a specialty occupation, they may also be painting themselves into a corner where those requirements may actually exceed what is permissible for a level 1 wage. And these are just things that employers are going to have to keep in mind and be prepared for in the coming months. So I definitely recommend that you consult with your counsel or have this documentation ready and prepared so that when the RFE does come, and it will, that you are able to respond to it and in a way that's going to make sure that the position does meet the specialty occupation requirements, but also does not push the requirements beyond what would be necessary for a level 1 wage. So the other important announcement, which is going to affect H1B workers, is the April 3rd, 2017 statement by USCIS that they were creating a program to deter and detect H1B fraud and abuse. And specifically, they stated that too many American workers are ignored or unfairly disadvantaged as a result of the H1B program. And so there's three focuses where there will be enhanced immigration enforcement in the H1B context. One, that is employers where basic information can't be validated through commercially available data. The commercially available data means the Dun & Bradstreet database, which USCIS uses to confirm their employers' information. And so, I apologize, the name of the database isn't coming right to the top of my head right now, but one thing that I do recommend to newer employers or employers that don't have an established credit history in the United States is to set up an account with Dun & Bradstreet and provide their information to Dun & Bradstreet so that that information will populate the database that USCIS contracts through Dun & Bradstreet, and that so that basic business information can be confirmed. Now, the next kind of group which is going to be targeted as H1B dependent employers, and there you're really going to be looking at firms which have high numbers of H1B workers who are not being paid the $60,000 that's required to become an exempt employer. And so this is probably few and far between at this time. I mean, there's just not going to be many companies which are paying their technical workers less than $60,000 a year. But there are going to be those companies which do have high numbers of H1B workers and would otherwise be H1B dependent employers, but for the fact that they pay their employees more than $60,000 a year. And I think that those companies should expect heightened scrutiny and site visits. Lastly, we should expect site visits for H1B employers who have workers at off-site locations. And so again, this is also going to affect those companies, pretty much all companies which are in the business of providing technical workers on a contract basis. So consulting companies, staffing companies, those types of businesses, which really are the ones which fall into these categories, and that includes those staffing businesses which are small and might not have that basic business information that is the first trigger that USCIS has announced. So here's really the key thing that has to be kept in mind for H1B, for companies that are employing H1B workers, and that is that your public and private files need to be put together. And so you need to make sure that those files are in order and the proper documentation is within them. If you don't have them, you need to hire counsel to have those prepared. And you need to provide your counsel with the proper documentation that counsel requests regarding wages, position descriptions, benefits, if you're going to expect that documentation to pass muster. And that's really the key thing that has to be kept in mind by H1B employers for this increased site enforcement that's going to be occurring, and that's really going to be affecting, again, consulting companies and H1B staffing companies. So that's the end of my presentation today. There's a lot happening in the world of immigration, and in fact, it's probably one of the most interesting areas of law to practice in right now, just because there's so much happening in all areas and aspects. So not just in the employment-based context, but in the context of foreign investment, in the context of family-based visas, and then especially in the context of humanitarian assistance that has traditionally been a part of what the United States immigration policy supports. So, I think that it's going to be an interesting year. I hope that you can take away some key points from the presentation I've given today. And if there's any questions, you're always welcome to reach out to me via email or telephone. My email address, again, is vchander@gardere.com, and my phone number is 214-999-4151. A copy of this presentation and the audio will be available on the firm website under my profile, so feel free to access that at any time. And just a disclaimer that I probably should have been given at the beginning of this seminar. The context of this presentation are not legal advice and may not be relied on for that purpose, and that this presentation does not create an attorney-client relationship. Thank you for attending, and take all the best to you. Bye-bye.